Power of attorney is like making a will. Once you have it in place, it's ready and it's there. I often tell my clients it's like an insurance policy. It's hopefully you don't need to use it, but it's there in case you do. Situations where you would need a power of attorney is if you were in hospital, if you were mentally incapable, you weren't able to access your own finances yourself. This is where the power of attorney will be able to be used. I don't think people realise the importance of making a power of attorney. Even your husband, your wife, your spouse, your partner will not be able to access your bank accounts if you were unable to access them yourself, if you were hospitalised, or if you were to lose mental capacity. Power of attorney broadly falls into two categories: property and finances and health and welfare. Without a health and welfare power of attorney, you may be excluded from decisions in relation to your family members' well-being for the future, if they were to go into care, what type of care they would to receive. It's important to have a property and finance power of attorney. If your attorneys needed to access your money, whether they needed to sell your home to pay for care fees or to go to the bank to pay for bills, you will need a power of attorney in place for that. Without the power of attorney, you will not be able to access any of their bank accounts or deal with any finances on their behalf. Power of attorney should be done as soon as possible. There is no age limit on power of attorneys. You can appoint one person or more than one person to act as your attorney. You can appoint your family members as your attorneys, your children. You can also appoint friends, family, even maybe your financial advisors or your solicitors. It's people who you trust, and that's need to be on your power of attorney. Once a document has been drafted, it takes up to 3 months for it to be registered and in force. So it's important that it's sent off to the Office of the Public Guardian and registered straight away so it's there and can be used if needed. Before any power of attorneys are released to your attorneys, we will make sure we receive identification from them. We will also ask the attorney to provide us with a letter from the GP confirming the donor has lost mental capacity. If you don't have a power of attorney in place, your next of kin will not be able to access your bank accounts to pay for any bills, and they will be forced to go down the court of protection route, which will be very expensive and time consuming. Nelsons offer a fixed fee for the service that we provide, and we also give special discounts when doing a will at the same time. Contact us to find out how we can help.